Good morning, everyone. This meeting is called to order. Mr. Trowman, do we have any public comment?
Good morning, Commissioners. Wes Trump, General Counsel. We have one individual registered to provide public comment this morning, Ms. Harrison. If you're there, go ahead and unmute yourself and begin. I don't believe she has joined us this morning. And with that, that's what we got. Thanks.
Thank you, Mr. Trowman. Good morning, Ms. Miller.
Good morning, sir.
All right, how we doing today?
Very well, thank you.
Well, good. No cases to reconsider under agenda item 3.
Correct, no cases.
Let's see, on tax liability cases under agenda item 4, we have no tax cases on docket 20.
Correct, no cases.
No fair housing cases under agenda item 5.
No cases.
Under agenda item 6, we have no wage claim cases pulled for additional discussion on docket 20.
Correct, none pulled for discussion, but you should have received the wage claim short form dissent list for docket 20.
I'll move we accept staff recommendations on the remaining wage claim cases on docket 20.
I second the chairman's motion, except for the cases on which I'm dissenting as reflected in the wage claim short form dissent list for docket 20.
I concur with Chairman's motion, except for those cases on which I am dissenting as reflected on wage claim short form dissent list for docket 20.
Motion passes with the exceptions noted.
Thank you.
Thank you. We'll move to agenda item 7 and consideration of unemployment insurance cases on docket 20. Please proceed when you're ready.
Case number 290-4619, Commissioner Dimerson.
The AG decision is not fully supportable. I agree that the employer had good cause to miss the first hearing. Concerning the timeliness of the employer's response to the NMPC, the employer gave credible and consistent testimony that the company responded in July 2021 after the employer received notice of the chargeback. The chargeback notice was mailed on May 11, 2020, during the height of the pandemic, when phone, fax, mail, and online systems were comprehensively overwhelmed. The employer's appeal from the chargeback determinations alleges that the company actually faxed an earlier response. Overall, the employer's credible testimony is sufficient proof of a timely response to the chargeback notice. Accordingly, we should modify the AT decision, hold good cause for missing the first hearing, find that the employer filed a timely response to the chargeback notice, and then resubmit the case on the merits of the chargeback issue.
The AT decision is supportable. I will not contest that the employer had good cause for missing the prior hearing. Regarding the timeliness issue, the employer's response was over a year late. The employer admits to receiving the notice and alleged to have sent an earlier response. However, the employer was unable to establish a date for the earlier response. There was no corroborating testimony from the disinterested witness, and there was no physical evidence specifically linked to the earlier response in question. As such, the employer's vague testimony is insufficient to establish a timely response date. Affirm the AT, employer established good cause, late response to notice of maximum potential chargeback, employer's account remains charged.
Modify the AT, employer established good cause for 81, timely response to the NMPC resubmit.
We will resubmit the case.
Case number 312-4020, Commissioner Trevino.
The AT decision is not supportable. After the claimant was laid off from his work, or his last work, he filed a UI claim in New Mexico, which is where he last worked, even though he resides in Texas. On February 1st, 2022, the New Mexico Department of Workforce Solutions informed the claimant that he did not qualify for UI benefits because the claimant had no base period wages reported in New Mexico. The claimant took immediate action and that same day refiled his UI claim in Texas. As such, the claimant presented adequate cause to backdate his claim to January 9th, 2022, which was the effective date of the UI claim he had originally filed in New Mexico. Reverse the AT, backdate the claimant's January 30th, 2022 claim to January 9th, 2022.
And we should affirm the appeal tribunal decision. The claimant testified that the DOL and TWC guidance he reviewed advised him to file his claim in the state where he worked during the base period. The claimant misinterpreted this and filed his claim in the state where his last work was located. Because the claimant filed his claim in the wrong state and did not contact TWC for clarification sooner, he has not shown adequate cause to backdate his claim. We should affirm the AT decision, deny the claimant's requested backdate. In the alternative, if my fellow commissioners believe that the claimant's request should be granted because the claimant first filed a claim on January 9th, 2022, his claim should be backdated to January 9th, 2022.
Reverse the AT, backdate the initial claim to January 9th, 2022.
The claim will be backdated to January 9th, 2022.
Case number 3270725, Commissioner Dimerson,
We should modify the appeal tribunal decision. First, I agree that the claim is valid based on a reduction in hours. Regarding the job separation, the claimant was discharged for sleeping on the job, which is prohibited in her position as a security officer. The employer learned of the claimant's actions from a client company witness who took a photo of the claimant with her head on the desk in apparent slumber while on duty. While the claimant denies sleeping, she does not dispute the authenticity of the photo, nor the fact that she was found with her head down on the desk. Worst case scenario, the claimant was sleeping on the job. Best case scenario, the claimant was not alert and maintaining a proper lookout while she was supposed to be carrying out her assigned duties. Under either scenario, the claimant mismanaged her position of employment. We should modify the AT decision, valid claim, misconduct, no chargeback, adequate employer response.
The AT decision is supportable. The claimant was partially unemployed after her hours were reduced for approximately 4 months after the client requested that the employer remove the claimant from the client's post. While the client made the allegation of misconduct, the claimant denied the allegation under oath. The employer's secondhand testimony and evidence of the allegation is insufficient to overcome the claimant's sworn denial. Additionally, the employer continued to use the claimant's services for other clients, which is further evidence this alleged incident did not rise to the level of misconduct connected with the work. The claimant has not restricted her availability for other assignments and has taken the posts that were given to her. Affirm the AT, claimant filed a valid claim, no misconduct, chargeback.
Affirm the AT, valid claim, no misconduct, chargeback.
Short form dissent.
Yes, sir.
case number 3276794, Commissioner Dimerson,
We should modify the appeal tribunal decision. First, I do not contest the good cause issue. Concerning the job separation, the employer's policy prohibited harassment and required employers to treat coworkers with respect. The claimant was terminated when the employer's investigation revealed that the claimant had taken an inappropriate photo of a coworker without consent. Since the record suggests that the claimant was aware of the employer's policy, but thereafter violated the policy through his inappropriate conduct, the claimant mismanaged his position of employment. As such, we should modify the appeal tribunal decision. The claimant established good cause for missing the AT1 hearing, misconduct, reimbursing employer not billed, adequate employer response.
The decision is supportable. The claimant had good cause for missing the first AT hearing because he did not receive the hearing notice in the mail until after that hearing date. Regarding the work separation, the employer discharged the claimant after he relied on misinformation from another employee who mistakenly believed that the claimant had taken a harassing photo of her. The claimant did not take a photo of the employee who reported the matter, and the claimant denied harassing or making unwelcome advances towards any employee. The employer presented no firsthand testimony or direct evidence to support any allegation of harassment against the claimant. Therefore, the employer did not meet its burden of showing the claimant was discharged for work-connected misconduct. Affirm the AT, claimant had good cause for missing AT1, no misconduct, bill reimbursing employer.
Affirm the AT, claimant established good cause for AT1, no misconduct, bill reimbursing employer.
Short form dissent.
Yes, sir.
case number 3290322, Commissioner Trevino,
The decision is not correct. The claimant's job responsibilities included day-to-day operations and handling of employer's cash. One of the owners began taking cash from the business. The claimant requested that the owner stop several times. On her final day, a substantial amount of cash was missing. The claimant resigned, informing the other owner that it was due to the missing cash. The claimant had been afraid to report the owner because she feared he would become violent. The claimant's fears were well-founded as the owner did in fact become violent when confronted. The remaining owners testified that he believed the claimant's actions were courageous. The claimant had good cause to quit as the owner was stealing cash for which she was responsible, despite numerous requests to stop. Reverse the AT, no voluntary leaving.
We should affirm the appeal tribunal decision. There is no doubt that the claimant had a legitimate concern that needed to be addressed. However, she did not bring this concern to any of the other three owners prior to quitting effective immediately. Had she done so, the employer could have taken steps to remedy the situation, which is exactly what happened when the employer learned of the issue. By quitting without giving the employer a reasonable opportunity to address her concerns, the claimant quit without good cause connected with the work. We should therefore affirm the AT decision, voluntary leaving.
Affirm the AT, voluntary leaving.
Short form dissent.
Yes, sir.
Case number 3364044, Commissioner Trevino,
The decision is not supportable. The claimant is the only party to provide testimony. The claimant was ill and drank a generic over-the-counter daytime cough medicine. The claimant has denied consuming alcohol at work. The employer has not provided any evidence to establish the claimant drank alcohol or a policy that prohibited the consumption of this medicine. None of the claimant's fact-finding statements indicate he consumed alcohol at work. The employer has failed to establish misconduct connected with the work. Reverse the AT, no misconduct, chargeback.
We should affirm the appeal tribunal decision. The employer's policy prohibited the consumption of alcohol during work hours. Although the claimant alleged he was drinking cough medication in lieu of alcohol, in his appeal to the initial determination provided closer in time to the separation, the claimant admitted to consuming alcohol in violation of the employer's policy. Since the record suggests that the claimant consumed alcohol and thereafter became inebriated at the workplace, the claimant's conduct was a violation of the employer's policy and was misconduct connected with the work. As such, we should affirm the AT decision, misconduct, no chargeback.
Reverse the AT, no misconduct, chargeback.
Short form dissent.
Yes, sir.
case number 33640, excuse me. Case number 3383926, Commissioner Trevino,
The decision is not supportable. The claimant is the only party to provide firsthand testimony that the claimant was informed her supervisor that had discharged and to turn in her keys and laptop. The claimant complied with her supervisor's instructions. Since the claimant's supervisor told her she was fired, there is no reason for the claimant to confirm that information with any other individuals. The claimant or the employer has not provided any evidence of misconduct. Reverse the AT, no misconduct, chargeback.
We should modify the appeal tribunal decision. Although the claimant's job duties entail marketing work, at a meeting with the employer on the job performance, the claimant refused to perform her required task, and when confronted by the employer, walked away from the job. Although the employer made repeated attempts to advise the claimant that she was not terminated, the claimant thereafter failed to clarify her job status or provide the employer the opportunity to remedy her concerns. Since the record shows that the claimant quit without providing the employer an opportunity to address her concerns, her needs, the claimant's separation was a voluntary quit without work-connected good cause. As such, we should modify the AT decision, voluntary leaving, no chargeback.
Reverse the AT, no misconduct, chargeback.
Short form dissent.
Yes, sir.
case number 3392601, Commissioner Trevino,
The decision is correct. The claimant posted a video of her social media from the office on December 2021. The claimant's manager told the claimant that she had thought the video was funny, but that the claimant should not post any more videos from work. The manager did not warn the claimant that she had violated policy or instructed the claimant to take the video down. The claimant complied and stopped posting any social media videos from work. Several months later, in April 2022, the employer discharged the claimant for allegedly violating its social media policy. None of the videos the claimant posted on her social media identified the employer or any patients or any confidential information. The employer neither provided nor specifically detailed their social media policy. Therefore, the employer did not establish that the claimant violated policy or engaged in work-connected misconduct. Affirm the AT, no misconduct, bill reimbursing employer.
The appeal tribunal decision should be reversed. The claimant was discharged for violating the employer's social media policy. The employer stated that the policy prohibited posting anything that was in poor taste related to the job, the coworkers, or patients. The claimant was admonished about the videos she posted online. Nonetheless, the claimant went on to post parody videos that were work-related. Given the nature of the videos, the claimant knew or should have known that her conduct would lead to discharge. We should therefore reverse the AT decision. Misconduct, reimbursing employer not billed, adequate employer response.
Affirm the 18, no misconduct, bill reimbursing employer.
Short form dissent.
Yes, sir.
Case number 3433198. Commissioner Trevino,
The decision should be modified. The claimant left the job after witnessing a tragic incident involving her husband, which left her both mentally unstable and unable to afford to continue staying in their home. The claimant had to move out of state and to stay with family. Since the claimant was both traumatized and facing eviction, she was forced to leave the job under circumstances that were urgent, compelling, and necessary, so as to make the separation involuntary under section 207.046 of the Act. Therefore, we should modify the AT. No voluntary leaving, no chargeback, urgent, compelling, and necessary.
The appeal tribunal decision should be affirmed while the circumstances leading to the claimant's job separation were tragic. The claimant resigned for a personal reason that did not constitute good cause connected with the work for quitting. We should therefore affirm the AT decision, voluntary leaving, no chargeback.
Affirm the AT, voluntary leaving, no chargeback.
Short form dissent, ma'am.
Yes, sir. And that was the last unemployment insurance case pulled for additional discussion on docket 20. You should have received the UI short form dissent list for docket 20.
I move we accept staff recommendations on the remaining UI cases on docket 20.
And I second the chairman's motion, except for the cases on which I'm dissenting as reflected in the UI short form dissent list for docket 20.
I concur with Chairman's motion, except for those cases on which I am dissenting, as reflected on UI short form dissent list for docket 20.
Motion passes with the exceptions noted.
Thank you.
Thank you. Is there any other order of business come before the commission? Is there a motion to adjourn?
So moved.
I second the motion to
Been moved
adjourn.
and seconded to adjourn, and we're adjourned.